Hello everyone, my name is Canelle Goldstein. I'm a Managing Associate in Addleshaw Goddard's Commercial Disputes team based in London, and I specialise in international arbitration. Thank you so much for joining this event on age diversity in international arbitration. I'm really pleased that we have with us individuals from a range of roles in the arbitration sphere, which I'm sure will give rise to diversity in perspectives and help with the discussion. So in terms of participants, first of all, we've got Laura Rich, who is the General Counsel at Marimaca Copper, which is a copper exploration company listed on the Toronto Stock Exchange. Prior to this, Laura held key in-house roles at Greenstone Capital and Acacia Mining PLC, and also worked in private practice at Sherman & Sterling. And as part of her in-house role, Laura has had some, I think it's fair to say, significant experience dealing with the management of disputes. We also have Anna Holloway, who is legal counsel within the Secretariat of ICSID and is based in Washington, DC. And prior to this, Anna worked as an attorney in the international arbitration practice of Wilmer Hale for nearly 10 years. Sabina Sacco is an independent arbitrator based in Geneva, who launched her own arbitrator practice, if I'm not mistaken, last year in 2021. She acts in a range of arbitrations, particularly in the Spanish-speaking world. And prior to this, she was a partner in Levy, Kaufman Kohler, and also practiced at White & Case. And last but not at all least, we have Shane Jury, partner at Addleshaw Goddard, who heads the GCC commercial disputes practice, has extensive experience in international commercial disputes, and has also recently started sitting as an arbitrator himself. Now, age diversity in arbitration is perhaps one of the less discussed types of diversity compared to, for instance, gender or ethnic diversity. But I suggest there remains a perception of some quite strong barriers to entry for younger practitioners who wish to sit as arbitrators, and also, by its very nature, repeat appointments of a select group of arbitrators. Now, not many arbitral institutions publish age statistics, but the ICC quite helpfully indicated that in 2020, the average age for appointed arbitrators was 56 years old. 37% appointed were under the age of 50. And very interestingly, in my view, the average age of appointed arbitrators when they were appointed by the ICC was 6 years younger than when they were appointed directly by the parties, which I think is a good segue into our first question, which is, why do you think that parties still show some reticence in appointing younger arbitrators, and particularly when they have already a lot of experience acting as counsel, or, and this is helpful addition from Sabina, as tribunal secretaries? Maybe Sabina, this is something, as you've helped with this question, if you'd like to kick off with it.
Well, thank you very much. First of all, thank you very much for the invitation to be here. It's a pleasure to be discussing this diversity issue with you, because I myself was a younger arbitrator at some point. I no longer consider myself to be so young anymore at the ripe old age of 47, but we all have to start somewhere, and it can be incredibly difficult for younger arbitrators to get started. And I think here is where the first problem begins. It's a little bit of a chicken and an egg situation, because everybody, counsel and their parties, want to always appoint the best arbitrator for their case. Even if it's a smaller case, you're always on the lookout for the best. But what is the best? And I think that when it comes to arbitrators, there's two key issues. One of them is competence. And for competence, how can we know if a younger arbitrator will be a good arbitrator if he or she hasn't had the chance to do this before? So there's a lack of information of the people who can actually deliver what is being asked. But the second reason, I think, is even more complicated to deal with, because as an arbitrator, you are an adjudicator, and parties, and perhaps here Laura will tell us what she feels from the counsel, from the party perspective. You're looking for a certain element of gravitas. You're looking for somebody who can exercise authority and that you can respect and trust, that will deliver the right answer, and not only the right answer in terms of the law, but also on the management of the proceedings. So you need somebody with a certain kind of expertise, but not only and experience in what I would call procedural savviness or procedural dexterity or due process common sense. You need somebody who really can be in charge of managing difficult procedural situations. So all of this, these are very high requirements. It's a high threshold to pass when you're young. So I think it's natural that counsel and parties will tend to want arbitrators of a certain age. But I don't, and here we'll go into it in the other questions, but I don't think that this is always a legitimate concern. I think it is, as a concern, it's legitimate, but I don't think it's that this means that you cannot ever appoint a younger arbitrator.
Thank you. Yes, I think, Laura, you might be the next natural speaker on this.
Sure. So I think, and again, looking at this from the perspective, from an in-house perspective of, and not necessarily something that is completely exit focused, any kind of dispute, be it with the government, be it commercial. I tend to look at this, I personally look at this in terms of the relevant experience, which points more to subject matter at times than it does to procedural savviness, because, and perhaps this is somewhat naive of myself, when you're appointing counsel to go to arbitration in a certain forum, you trust that the people who are being selected as arbitrators have the relevant level of procedural competence, if you will, to be selected. But the bigger issue that I have had in certain disputes that have been highly technical, highly complicated, certain constructions disputes, say, or mining disputes, is not whether or not there is the procedural knowledge there. It's the actual ability to look at the more technical components of the dispute and read the law in that context, or a dispute in that context, because and this is perhaps not necessarily completely age driven, but certainly from an expertise driven point of view, there are many incredibly experienced arbitrators and very renowned and respected arbitrators that might not necessarily be the best fit, say, for a mining dispute, but would be, kind of like a first choice for selection for even, very experienced counsel. So for me, it's more trying to figure out what is the best fit in experience for a dispute that doesn't automatically point to age in one direction or another. But I do, obviously, what Sabina's just said, it's very difficult for up and coming arbitrators to get experience, and you do find yourself where some very promising practitioners who could also be arbitrators aren't getting the opportunities that they should get that would ultimately benefit the end user.
That's really helpful, thank you. And Shane, do you, maybe from a practitioner's point of view, do you have any views?
Yeah, absolutely. Great to be discussing this with all of you on Valentine's Day. Hopefully there are more exciting plans after this, but it's an interesting topic, and it's certainly something that is perhaps overlooked on the diversity discussion in arbitration. I think rightly there's been a lot of focus on gender diversity, and we've made improvements in recent years in that space, but I think age is something that perhaps has been slightly overlooked, partly because younger arbitrators are less visible. So I do think it's something that requires attention. In terms of the reticence in appointing young arbitrators, I completely agree with Sabina that part of the problem is how do you gauge whether a young arbitrator is right to deal with the issues in the case. I've seen many cases where you look to appoint an arbitrator based on their reputation for seeing issues in a particular way. So you might describe someone as a black letter lawyer or a black letter arbitrator because they're seen to approach the issues in that way. They've got a track record. So there's that predictability in appointing candidates that you're familiar with. Obviously, that tends to favour the status quo. In addition, I think there's a real problem about lack of information. So in terms of making those decisions, I very often see firm-wide emails going around where my fellow partners will have a list of individuals. They'll ask if there's any intel on those individuals, how they tend to deal with issues. And I think that goes to Laura's point as well, but in terms of the industry knowledge that young arbitrators might have or not have in a particular given issue, it tends to disqualify them from a lot of appointments. So I think there are a few issues, that the lack of information, the lack of sort of transparency, and I think in some places there's a cultural dimension as well. So Sabina mentioned the importance of gravitas and having someone who can deal with issues in a procedurally robust way. Certainly in the Middle East, there is a great cultural tradition of respect for elders and the leaders. So I think that's part of it in certain regions of the world as well.
Yeah, absolutely. Thank you. Those are really helpful points. And Anna, maybe would you like to add anything from an institutional perspective? Obviously, there's some helpful points made before the recording started about maybe the range of ages being a bit different in different types of arbitrations. The floor is yours.
Sure, thank you. I mean, it is definitely true that what is young in an investor state dispute context may be a little bit older than what is young in a commercial arbitration context. But the question of what prevents young, however it is defined, arbitrators being appointed in each of those spheres probably comes down to a similar set of reasons. And I agree with everything that has been mentioned so far. I think Sabina had mentioned that parties want the best arbitrator, and I agree with that, but also I think parties may want the ostensibly best, the defensibly best arbitrator. And there comes a sort of a psychological issue for those making these ultimate decisions, a fear that if things all go south in the arbitration, it doesn't go the way that they want, that their decision 3 years or 4 years or 2 years down the track is defensible to their boards, or in the case of investor state disputes, to their governments, to their executives. So I think that tends to push people more towards safe choices. Another factor I think is relevant is also the age, potentially, of those people making the decisions. Sometimes 65-year-olds might feel hesitant about appointing someone who's the same age as their child, as arbitrator for their disputes. So I think as we see age diversity increase in decision-making spheres, both at law firms, in-house roles, and within government legal departments, that changes a little bit. And I would also say that in the investor state context in particular, younger candidates are more likely to be at law firms. They're less likely to be out practicing independently in their early 30s or beyond. And so at law firms, there's a greater scope for conflicts, and also a greater scope for concerns regarding double hatting that may be particularly relevant in the investor state context. And so those concerns, I think, can lead people away from those younger candidates who are at big firms with a lot of cases going on.
Yeah, again, and I think that's quite a tough question to answer, because again, I think it really matters or depends on the nature of the dispute and the party to the dispute, and whether, frankly, you think that there could be more fun and games than there would usually be in the conduct of proceedings, which then points you automatically to somebody who's incredibly strong on procedure. But when you're actually, again, I think I've seen young-ish, I'll say, given the age range we're talking about in terms of young arbitrators, more in the likes of relatively small to medium-sized construction disputes that tend to be highly technical and veer into kind of like the engineering world, if you will, as opposed to the disputes I've been involved in between investors and governments, where you anticipate more shenanigans than you would in a true commercial dispute. So I think it, again, and I do keep labeling this point, I think the benefits of younger arbitrators, and also the way for younger arbitrators to gain more experience, is through the more technical arguments, where people want the technical focus, but also where people are also looking to resolution in an expedited manner, rather than in the ordinary time frame, if there is such thing as an ordinary time frame for ICSID disputes. Because again, looking at this from a corporate perspective, and looking at it from the perspective of certain board decision making, one barrier generally to companies pursuing arbitration is cost, but also time. And I think it's important to, and sometimes the appointment of younger arbitrators or youngest arbitrators point to a greater level of efficiency, or than say something that's more protracted, that requires more more kind of long-winded kind of procedural overlay.
That's really helpful, thank you. I don't know if maybe Shane or Sabina, you want to jump in on that?
Yeah, happy to. I think there are sort of 3 points that I would make. The first is the technological factor. So obviously younger arbitrators have grown up more steeped in technology. They're used to the fast changing world that we're experiencing today. They perhaps have more experience with platforms like Relativity, know a bit more about data analytics and the benefit of that sort of review process. So when they're faced with some of these procedural issues, particularly in really data and document heavy cases, it may be that they do make different decisions than you might get from your 65-year-old retired English High Court judge. So really the technological point is the first one, and I think it's a powerful one. The second is subconscious bias. Obviously, young arbitrators have a very different frame of reference of the world. They've grown up with a number of different trends shaping their generation, including globalization, the pace of change, uncertainty in the world. So obviously they look at things with that background and that lens, which again may promote better decision making because they have a different point of view. At the very least, I would expect it would promote a stimulating discussion amongst the tribunal members. And thirdly, I would just say there's an argument in terms of developing the profession. We need high quality arbitrators in the future. They're not going to wake up overnight having never sat as an arbitrator and suddenly be excellent at dealing with procedural issues. And I think, this goes to Laura's point as well, that maybe if they can cut their teeth on the smaller value, perhaps slightly more technical in terms of the expertise cases, but perhaps with a smaller quantum, there is an argument there that, well, we're creating the next generation of arbitrators, and it's important that they get that experience. And I think if you look to the civil law tradition of, judges actually being trained to be judges and they start quite early on that career path, I think there's an argument to be made that arbitrators should have a similar opportunity.
Yes, no, I second everything that's been said, but I have a few comments. I'm gonna start first with what I think are the two benefits, the two sort of salient benefits of having younger arbitrators, and I can summarize them as enthusiasm and humility. So enthusiasm because these arbitrators are going to be, they're so enthusiastic about having these cases in the first place that they're going to devote so much time and energy and in getting it right, because they want to make sure, they know that their future appointments depend on doing a good job. So they're going to really make an effort. And this, I think, translates into diligence and potentially efficiency. But I want to go back on the efficiency point later. The second is humility. And here I want to go into questions of cognitive bias. There are many studies that have found that decision makers, whether they're judges or arbitrators, are subject to all sorts of cognitive biases. And I'm speaking here of heuristics, so basically automatic, unconscious, intuitive decisions. And this is because we're human beings, right? But I think there's a tendency for older arbitrators to be more subject or more prone to intuitive decisions because they come with confidence and experience. And so you think that you know about these things, you've done these before, you've seen this before in your life, so you don't have to necessarily think them through so well as you would have done when you were younger and you didn't have the experience. So here, this is where lack of experience actually helps, because instead of relying on intuitive decisions, younger arbitrators are going to do the work, and they're going to go through very deliberate, rigorous decision-making processes. And so I think that actually helps. This is a benefit that people tend to overlook. If you appoint a very experienced but very busy 65-year-old arbitrator, I'm not sure you're going to get the same result. But I mean, you might, but it really depends on the arbitrator. So those are the two benefits that I see. But I just wanted to briefly go on the point of efficiency that Laura had made. And I find it's a little bit contradictory, the expectations that we have on younger arbitrators, because yes, I agree that if you're on the board of a large company, you're going to want the younger arbitrator to do an expedited proceeding. Because, well, first of all, an older arbitrator might not actually accept the appointment because you don't get paid very well for expedited proceedings. So that's a point that needs to be understood also. So your pool for expedited proceedings, your pool of arbitrators is smaller, and it is a pool of younger arbitrators. But the problem with this is that many of these expedited proceedings require arbitrators to take very risky decisions, such as, for instance, not hold a hearing. And you need procedural experience for this. To make this kind of decision. So I know that we're going a little bit off point here, but I just want to say that requiring a younger arbitrator to be more efficient also requires him or her to take certain procedural decisions that maybe he or she is not experienced enough to make. And this is a question that I think maybe should be made, a point that should be made to arbitral institutions more than to counsel of parties, who obviously are looking for some sort of relationship between quantum and age. But I think that is a point that needs to be taken into account. Well, I can go first, and I think that unfortunately my answer is I don't think I have seen a real change. I mean, to me, to my eyes, yes, it seems a little different, but I now realize I'm no longer so young anymore, right? I must have gotten my first appointment around 40, but I was a late starter. I have friends who have received their first appointments at the age of 33 and have done very well, but they have been the exception. And I would say I know extremely qualified arbitrators, young arbitrators who are struggling because they're still in their 30s. And there's nothing I can say to them except you need to wait, because the people who are going to appoint you are your peers. So it's what I think it was Anna who had mentioned this before. I think it depends on who's making the appointments, and people tend to trust people their age a little bit less so those who are younger. And so, you know, when your peers start to become partners at law firms and general counsels, etc., then I think that they will consider you as having sufficient authority to have these kinds of positions. So yes, I cannot really. It's difficult for me to say because it's not like I go around asking people. But I do know that I am, with the exception of one case, I am the youngest arbitrator in most of my cases. Mm-hmm. And so, and I'm no longer so young. There you go. So
that's really helpful to know. Anna, from your perspective, have you seen anything?
Yeah, ICSID doesn't report statistics on ages of their arbitrators. You know, we know the ages of some because, as you all know from your own contexts, people sometimes put their year of birth or at least, you know, the year of their first degree on their CVs. It is something that we think about from that sort of global advancing the pool of arbitrators perspective. I do think I have seen increasing young appointments, and again, this is young in the ISDS context, over the last 5 years. And I think I've seen that come from two places. The first is from appointments made by states. In my anecdotal experience, those arbitrators are more likely to be young. There may be appointments made by investors. And I don't know why that is. I have a theory that in part it stems from, for many states, having relatively young groups of lawyers representing the state in their own governmental departments. And this goes back to Sabina's point. If you've got a bunch of 45-year-olds making decisions for the state, they may be more comfortable appointing a 45-year-old arbitrator than if they were substantially older. So that's, I think, one thing. The other thing where I have seen it elsewhere, I think it may stem perhaps from an increasing consciousness among counsel, among in-house counsel and also external counsel, but also among co-arbitrators, to increase diversity across the board. in appointments, and it's just the natural corollary of looking at some of the other aspects of diversity that often are more focused on than age, that also those folks tend to be a little bit younger. There aren't a lot of there aren't as many females or non-white male 70-year-olds out there as there are arbitrators who are in the younger cohort, but also are diverse in other ways. And so I think you may see some age decreases as a consequence of pushes elsewhere in the diversity sphere.
Just one comment on the statistics. So you mentioned that I think it was 37% of arbitrators were under the age of 56 with the ICC court.
Under the age of 50.
50. And one observation that there's been a real generational renewal of the ICC court. So I think it's 55% of its members are now below 50 and 15% are below 40. So I do wonder if that trend continues of that sort of generational renewal in the appointing bodies, hopefully we will see younger arbitrators continuing to have those opportunities, because I do think that, as someone said earlier, you tend to appoint people who are like you. So hopefully that's a positive trend that will continue.
Sure. I mean, the obvious thing is to appoint younger arbitrators, right? I mean, many institutions have often vested by parties in appointing authority. So that is one thing. But I think that seems obvious. I think there's a question for what else can be done. Institutions like ICSID don't just appoint. When we do appoint, we are limited in a convention, ICSID convention context, to appointing from a panel of arbitrators, and that panel is constituted by our member states who appoint 2 or 3 names periodically. So we can only appoint from that pool, and so it depends really on who the states have appointed. We can encourage states to keep their appointments up to date. It's disappointing when you open the list and realize that this person is retired and that person has unfortunately passed away, and the list isn't as long as it appears. So certainly outreach there to ensure the pool of available individuals for appointments is at least up to date from the state's perspective, whether they value age diversity or not is sort of for them. But beyond our Article 38 appointments, we do a lot of work preparing ballots for parties at their request. They can either be just a basic ballot or a strike and rank mechanism, and the names that we suggest to the parties in that regard are not limited at all. And so I think one thing I've noticed over my time at ICSID is that names that we were placing on ballots 5 years ago that weren't being selected are now being agreed to by the parties. And I think there's a lot to be said just for exposure, name exposure. If you are putting, a young, for our context, arbitrator candidate on a ballot, and it's going to one of these big law firms that are often representing parties at ICSID, they may review that person and reject them offhand 5 years ago, but as they see the name again and the person gets older and more experience, they become more comfortable with that as a possibility. So I think that's one thing. And the other thing is just other outreach options that enhance young arbitrator practitioners or arbitrators' profiles. So we have Young ICSID. I know the ICC has its own entity sort of seeking to promote younger arbitrators. So those are the things that I think are most obvious that institutions can do. But I'm interested to hear what those of you who use institutions rather than work within them think.
Yeah, sure. So my first appointment was as a sole arbitrator on a DIC LCIA case, and but that was an appointment by the LCIA court. I think primarily it resulted just from my market profile in the region, having been in Dubai practicing for close to a decade, very active in arbitration and litigation circles. I think it's perhaps a bit easier in developing markets to secure those first appointments, just given the, it's a bit easier to make a profile for yourself. There are fewer candidates compared to developed markets. So I suppose my personal situation is a bit different to the standard situation if you're in a more developed market. But in terms of what could institutions do, I think really just transparency is quite important in terms of reporting on statistics, doing that in a standardized way, perhaps promoting potential candidates in a more visible way in terms of who is currently sitting as an arbitrator that is younger. Greater publication of awards, more information regarding availability and costs. But that said, I think there's only so much the institutions can do. We're looking at approximately, I think, 25% of all arbitrators on ICC arbitrations are appointed by the institution. The other 75%, of course, are candidate nominated by the parties. So really, we also need to bear some responsibility as a profession to be brave and suggest candidates who are outside the traditional box in all respects, whether it be gender, ethnicity, age, and so on. And of course, D&I is on the agenda of all of our clients. It's an issue that affects every C-suite executive. It's important. The days of very senior practitioners being wheeled out at the beauty parades without the junior members of the team are long gone. So I think the willingness is there on the part of our clients, and we've just got to embrace it perhaps as a profession a bit more. But I'd be curious to know Laura's take on that as well.
As you see me smiling in the corner here. Look, it's a very interesting point. And again, I think if you look at kind of the conveyor belt of individuals that are involved in dispute, a lot of the selection process can actually come from whether it be even the selection of counsel into the selection of arbitrators, almost kind of like a client focus. And a lot of it can actually boil down to whether the client has an in-house legal team who is a client representative, the extent to which the client is willing or wants a certain level of input into a dispute. Certainly from my perspective, I have always been heavily involved in all of the disputes I've managed, to the degree that I wanted to see the witness statements. I'll mark them up. I'll, probably a bit of a tough customer for some, as opposed to a more kind of a sole business appointment that will hand over dispute to a firm and pretty much let them make all of the strategic thinking and the strategic decisions and the selection of the panel. So it's the same when you're appointing law firms, or the same process feeds into the selection or the input that you want in the selection of the tribunal. It's whether or not you are engaged in running your dispute and the drivers and the setting that you want to create for that. I know, having worked with a lot of different firms and disputes, every firm has its way. Certain people have a bigger say at a certain stage than others, and you can certainly see some of the the internal politics when people are putting forward various different individuals to be a tribunal appointment. And I think it is it's as hard for a law firm to take or to promote age diversity in the event that they are questioning whether or not this could have a significant impact on the outcome of a dispute. Maybe it does need to be more client driven, based on who the client is and where the client in question is going, and what they believe are the important components that really need to be understood in a dispute. And certainly what you see in, not necessarily in to the extent that CVs are anonymous, or the descriptions can be anonymous. It's very interesting to see what the drivers will be if you are making decisions on the basis of the experience and the achievements listed alone, not over a time frame, because one would argue that you can achieve a hell of a lot more in 30 years than say in 10.
I think it's a really good point. If I can just add to that, I think, at the end of the day, our duties are, of course, to our clients, and we've got to make sure that we're promoting candidates that serve the best interests of Laura's organisation or whoever's organisation we're acting for. So I do think there is a tightrope as practitioners. We do need to walk between, promoting diversity within those bounds. And I think, therefore, you're right, Laura, that a large part of it needs to be client-driven to some extent.
Or at least client, very heavily client probed, so that it has to be a case of this person is, this person is world renowned because of this person is this person, which often is the justification for making certain recommendations, for the appointment of tribunals. There needs to be more diligence on whether, the suggested appointment is truly the correct fit for the dispute that you want to, present before them.
And if I can interject there, I think everything you've said is absolutely true, and I think it all boils down to awareness of the problem and awareness of the pool, because I think that one of the things that we can do to promote age diversity is to make sure that clients and institutions are aware, first of all, that a younger arbitrator might actually deliver better results than an older one. So this is a question of just knowing what a younger arbitrator can do for you if he or she has the right experience. And then the second is to know who are the younger arbitrators out there. And I think it was Laura who touched on this. I think one of the most underestimated group of people is tribunal secretaries. But you can be assured that somebody who's been working very closely with the chair of the tribunal has seen how the chair of the tribunal deals with certain procedural issues, has proposed ways of dealing with issues and perhaps have been overruled, but is learning how to deal, and is learning how to draft, and is learning how to efficiently resolve disputes. And I think that is key. So if we give these people a chance, or I think that we can have a greater pool of more diversely aged arbitrators. And here it's two groups of people who need to know: counsel and their parties, so clients as well, and institutions. And institutions are doing a great job of trying to push these people forward, but they can only push those people that they know. So I think that we need to come up with ways of having databases or other ways of having, let's say, a list that is growing with objective characteristics of different people who can do the job, and share that with arbitral institutions or with clients. I think that this is one of the ways that we could certainly promote age diversity. And in this regard, I think that if you are a client and you're looking for an arbitrator and you don't know whether a younger arbitrator might be a good choice for you, I would say that a good rule of thumb is that if this person has been a tribunal secretary for a certain number of years and has perhaps already received his or her first sole arbitrator appointment, he or she might be ready for a chair appointment. But if you have a younger arbitrator that you're considering who has not been a sole arbitrator and has not been a tribunal secretary, I would really hesitate to put him or her in a chair position. I think that these people who have normally been working as counsel or partners at law firms should start first with a wing appointment, because this gives them the opportunity to contribute, but not necessarily to carry the proceedings forward.
Thank you. Sorry, Laura, I don't know if you wanted to add something there.
No, I agree, and again, I can't see why there's such a barrier to that approach. To me, that just seems like a common sense perspective, and you're getting the best level of inputs for decision making, because of the various skills that are brought to the table. And it would be interesting to see if that could become a rule of, an actual form of guide and some kind of explanation as to why that can't be the case.
I wanted to add something to what I can't remember who mentioned this, but when institutions are providing the parties with ballots, with lists of potential candidates, there is something to be said for promoting these candidates a little bit more, the way that law firms do. I mean, law firms, when they present a client with potential candidates, they've done a briefing on who's who and what they've done and what they can do in the future and why do we think he's good or bad. And I think that, I know that institutions have a lot of work. Sure, that's I don't want to add more, but there's something to be said for providing states, for instance, or parties with a list not only of who are these people, but why we've included them here. Why do we think that they're ripe for your case? And I think
sorry, carry on.
So just to finish, I think that having that input from the institution would perhaps help settle any concerns that clients may have about somebody's readiness to take on a particular position.
Yeah, I was just going to say that would be a huge benefit and an incredibly helpful piece of information to help to feed into decision making with a lot of states, I would imagine, as well as investors, given certain issues with capacity. So yeah, I think that would be of huge benefit.
If I can circle back on that, it's interesting to hear that perspective that you share, and I can see as a practitioner why that would be immensely advantageous. There is, of course, a balance in terms of what role does the institution actually play. We can't be I guess we are, and sometimes in the business of selecting arbitrators for cases in terms of actual appointing authority. But at the end of the day, the decision making for agreed appointments has to be that of the parties. And I think that there is sort of a difficult line to tread as an institution in terms of saying this person is good for this type of dispute for these reasons. One, there's obviously it's burdensome, but also it's just a question of whether we as an independent institution should be playing that role of recommending one individual over another. And in a list, we provide curriculum vitae of candidates to the parties, but those are simply the CVs that are provided to us by candidates themselves. So there's no uniformity there necessarily.
That is extremely helpful and insightful, and thank you so much.